So welcome everyone to the next installment here at Berkeley Law. It's our Berkeley Law Center for Technology's Expert Series webcast, and we have a unique program. It's material you don't often find on the West Coast experts. So we went to the East Coast. So we went straight to DC to find the true experts. You find the problems on both coasts, just not the experts. So with us, we have for Morgan Lewis, two partners out of the DC office, Raechel Kummer and David Plotinsky. So again, both partners, if you look at Raechel's career and background, pretty impressive list of cases, pretty broad listing of courts. When I was looking at the appellate courts that you've worked in, it's hard to find one that you haven't been in. But you're looking at an expert in government investigations, litigation, class action litigation, and a lot of internal investigations as I went through your bio. And with her, David has a really unique background. Actually, I think you're the first person I've done any of these programs with that actually had any experience with the foreign investment review section, but definitely the only one that was the acting chief. So it's nice to have your level of expertise here on FISA, foreign investment, and then government investigations. So as a retired patent litigator myself, all of this is incredibly fascinating. And I tell people, if you can keep my attention for 50 minutes, patent litigators have short attention spans. You've done a great job, and I'm really excited about this one. So with that, I'll get out of the way and turn it over to the two of you.
Well, thank you very much. Again, my name is Raechel Kummer, and I'm a partner at Morgan Lewis in Washington, D.C. I want to start by just thanking the Berkeley Privacy Law Forum for inviting us to participate in this important program, and by welcoming everyone who's going to join us to hear this program, for joining the conversation on privacy, FISA, and national security. So in my practice, I generally focus on complex commercial litigation, class actions, and appellate law. And I advise our clients that are facing congressional and other governmental investigations. And a lot of my practice is focused on our technology and e-commerce clients. So through that space, I have developed a significant experience in privacy law, particularly dealing with issues of biometric privacy, and as relevant here, with FISA. And so I really look forward to this discussion with you and with my partner, David. So David, do you want to introduce yourself as well?
Yeah, oh, sure. Thank you. And yeah, it's good to be here. Appreciate the invitation. So I've been with Morgan Lewis almost exactly 3 years. I'm hitting my 3-year anniversary this month. I guess for anybody not watching this live, we're recording this in January of 2025. I was in government for 25 years before coming over here, 10 years on Capitol Hill, and then 15 years in the executive branch, doing a variety of national security things. I'll spare you the sort of long version of my bio, but a couple of just quick highlights. So on the Hill, I was in the General Counsel's office for the House of Representatives, and then I had a bunch of jobs in the executive branch, including being the chief of litigation for ODNI, which is the Office of the Director of National Intelligence. I was also the chief of the cybersecurity division at the Federal Communications Commission. And then I spent most of my time at the Department of Justice, and immediately before coming to Morgan Lewis, I was running an office, that Wayne mentioned, the Foreign Investment Review Section, which does a lot of work involving sort of the intersection of trade and national security and policy. And that's largely what I advise clients on now. So my practice is sort of all over the national security map. And I guess it's interesting that we are here doing a privacy-focused webinar, because, Raechel, when I think about you, the first thing I think about is not a privacy lawyer. I kind of think of you as hardcore litigation, appellate stuff, and probably when you think about me as a national security guy, sort of like the knuckle dragger at the firm. And yet here we are talking about privacy.
I mean, it's a hot topic in litigation, and it's a hot topic in the government sphere as well. So it makes sense, but I take your point entirely.
Yeah, and look, I mean, this is a broad field, and there's certainly, I think, as you and I had sort of talked about this webinar and what we would address, I think we realized more and more how much work you and I do that does sort of intersect in some way, shape, or form with privacy. And I guess we're going to start with FISA. And, Raechel, I think, you're going to cover most of it. So maybe just before I kick it back to you, I'll just tell you sort of, autobiographically, FISA is near and dear to my heart because it was really my own introduction to national security. I've been on Capitol Hill for 10 years, including, in the immediate aftermath of September 11th. So I'd done plenty of national security work. I did a lot of work for the House Intelligence Committee. And so it was part of my portfolio, but I was not primarily a national security guy. And then I decided to pivot to do that exclusively. And so my first job was at the Department of Justice in an office called the Office of Intelligence. And basically what they did all day long was FISA, right? I was there for a couple of years before going on to other things. But I'm thinking about this now in the context of our privacy webinar, Raechel, because when I left DOJ, I went out on detail to the National Counterterrorism Center, where I spent a couple of years. And I remember going into the office one day and opening the Washington Post, and there was this huge front page article about a super secret government program that was involving bulk collection of data, right? Using FISA authorities, metadata, right? But still bulk collection of metadata. And nobody knew at the time where the leak came from. We discovered very quickly that was, the first of many Edward Snowden leaks. So I took that kind of personally, right? Because at DOJ, that was one of the things I've been doing. And although I worked in an office, where everybody had, the highest level security clearances, those of us working on that program couldn't even talk to other people in the office about it. It was so compartmented. And that led to a huge national debate about privacy and FISA, and is it too broad and should it be cut back, including Section 702, which you'll be talking about a lot today. And so those are all, valid discussions to have. But, I got to tell you, and obviously I'm biased because I was doing the work. I think a lot of the concerns about privacy were a little overblown because what folks didn't fully appreciate is the huge amount of oversight that went into all FISA programs, but especially programs like that bulk collection program, right? I mean, the more collection you're doing and the more sensitive it is, the more oversight there is, both by the FISA court and by the Department of Justice itself. So, we didn't just go and get authority to do FISA search and surveillance. We also did very active oversight, flying all over the country to FBI field offices and other places to look at the FISA take and make sure that it was being collected and handled in accordance with the law, including minimization procedures and other things designed to protect privacy. So there's a lot of safeguards baked into it because it is such a powerful tool. That was kind of how I started my national security career, and that was way back when. But FISA is still sort of front page news, especially over the past couple of weeks. So it's timely for you to be, talking to us all about your thoughts about Section 702. So maybe kick it over to you to do a deep dive on FISA stuff.
I really appreciate that, and your background on FISA and the fact that that's sort of how you got into national security is extremely fascinating, and it is an unusual, I think, overlap between our different career trajectories, and that I had handled a number of national security, I guess, related issues in defense of various congressional investigations in my practice. But the first national security issue that I dealt with really as a litigator in court was a FISA issue in the DC circuit. And so, I think that's interesting. It pops up both with the government and even in private practice. And so I think it's important for us to talk about FISA in this series this year, because one of the most prominent conversations about privacy in 2024 involved whether to renew Section 702 of FISA. Now, that's a particular section, which is the warrantless search section, and I think I'm going to focus on it today. Congress passed Section 702 back in 2008, and the law has been repeatedly renewed since then. But then last year, in what turned out to be a very last-minute actual midnight vote, Congress renewed the section again, and it expanded it. That renewal, though, in a compromise, is only going to last for 2 years. It's a time-limited renewal. And so I think it's really worthwhile for us to delve into this discussion about what animated whether to renew Section 702 in 2024, both backwards looking over the last several months and the last year. And also because, the law is going to come up for renewal again just next year in 2026. And there will be some ongoing conversation then, whether it's heated the last time around, I don't know. But the conversation is going to continue.
Yeah, and so Section 702 was sort of brand new when I started doing this work, which is now a while back. Now obviously it's been around for a while and the tire's been kicked. But for people who don't sort of live and breathe this stuff, maybe you can start by giving us just some general background on Section 702. And when you talk about, warrantless searches, what does that mean in this context?
Yeah, I'd be happy to. So really after September 11, the government began certain intelligence functions that were formalized into what's known as Section 702, which allows the government to target non-US persons who are reasonably believed to be located outside the United States to acquire foreign intelligence information. And so when targeting these non-US persons overseas for foreign intelligence, under Section 702, you don't need a judicial finding of probable cause to do so. Instead, the Attorney General and the Director of National Intelligence can jointly authorize certain warrantless surveillance of these non-US persons subject to protocols. And I think that's important, and it loops back to your initial introductory point that, there are regulations here, there are protocols, there are specific targeting, minimization, and querying procedures that come into play, as well as supervision within the government itself.
And I recognize that not just out in California, but in DC and elsewhere. When we say, "Oh, don't worry, there are safeguards," that may not give some folks a lot of comfort. They may say it's sort of the fox guarding the hen house, because it's still trusting the government to police itself, which doesn't always give folks a lot of comfort. So recognizing that, and again, these are legitimate things to be concerned about. What are the privacy issues for U.S. citizens?
So I think the main privacy issue for US citizens is that although Section 702 and FISA can't be used to target US citizen communications, some of those can be incidentally collected. And so I think it's worth talking about how does practically Section 702 collection, how does it work? And there are really two types of collections. They're generally referred to as like upstream collections and then downstream collections. And in an upstream collection, the government can intercept and copy what are international internet communications as they flow in and out of the US in a form of bulk collection. And then the government can run searches on that collected data for key terms that are associated with foreign targets. Alternatively, there can be what are called downstream collections. And that's when the government will obtain communications like emails or internet calls that are obtained directly from US companies. Previously technology, social media companies of that nature, where the government identifies a specific US, non-US person account that it wants to monitor. And then it'll order that company to disclose the communications to and from that account. Now, as you said, like, I'm an appellate lawyer, and so I really like to focus on what is the precise language of the statute. And I think that's particularly important here when we talk about who has to facilitate downstream collection and how we end up in the privacy discussion that was so heated in the last year. And the key statutory term is an electronic communication service provider, which is a mouthful. And so sometimes it's called an ECSP, which is also hard for me to say without a slight lisp, nonetheless. So under the statute, the AG and the Director of National Intelligence can direct an ECSP to immediately provide the government with all information, facilities, or assistance necessary to accomplish an acquisition in a manner that will protect the secrecy of the acquisition and produce a minimum interference with the services that the ECSP provides to the target of that acquisition. So what does that mean? Basically, it means that the government can compel an electronic service communications provider to turn over intelligence without alerting the target of that surveillance. Thereby, we end up with some privacy concerns. this isn't you don't have to get a normal, you don't have to have a warrant, but there are courts involved, and one of the main courts is the FISC. And so last year, the statute was ultimately renewed in April, but at the end of April. At the beginning of April, in early April, before FISA was renewed that very month, the Foreign Intelligence Surveillance Court issued an order in which it recognized that although Section 702 surveillance isn't intended to sweep up private U.S. person information, either in a bulk or in an indiscriminate fashion, despite the limits on acquisitions, that large amounts of private U.S. person information are likely to be acquired. And so, when a U.S. person's information is collected, it's generally referred to as incidentally collected information. And how does that happen? All right. So sometimes the government may incidentally obtain U.S. person information where the foreign intelligence target, who is reasonably believed to be a non-U.S. person who is overseas, has communicated with a U.S. person. Or alternatively, where that non-U.S. person overseas themselves possesses U.S. person information. And once the government incidentally collects that U.S. person information, again, subject to certain procedures, the minutia of which we really can't talk about on a webinar, it doesn't really facilitate that, but there are procedures. Nonetheless, the NSA and the FBI can run warrantless searches on that information. And so early in April, before the statute, Section 702 was meant to be renewed, or whether it was going to be renewed, it was going to have a sunset. This FISC order really made public a discussion of what the court called, quote, the prevalence of non-compliant FBI inquiries, which had already been a major focus of concern since that same court, the FISC court, had found previously in 2018 that is likely to be implemented. The FBI's querying and minimization procedures were not consistent with statutory or Fourth Amendment requirements. And that order by the FISC court really fueled the privacy debate about whether to renew FISA in 2024 or not.
Yes, that's interesting, Raechel. And I get the fact that this time we had that FISC decision that fueled the debate. I do get the sense, though, that we keep going through this, right? Every time 702 is up for renewal, there's a lot of hype, and people get spun up, and they're afraid until the last minute that it's not going to get renewed, and then it gets renewed. And as I mentioned before, I mean, this has been around now for a while, and we've had a chance to kick the tires. So this is not the first rodeo. So can you maybe just give us a sense of what was the flavor of the renewal debate this time around?
I think it's a really good question. Heated is the answer, because there are just really important concerns on both sides. The national security interests are extremely important, and the privacy interests are extremely important. And I think particularly given that we just had the recent inauguration, we have a new administration. President Trump has come back in. I think it's important that the FISA debate, it doesn't even break down on traditional party lines. There's a real division within the Democrats and within the Republicans on privacy versus national security, and which concern should govern, which is why I think this is a recurring debate whenever FISA comes back up for renewal. So, there are privacy advocates like the ACLU, the Brennan Center, and the Electronic Frontier Foundation who really view FISA as a serious threat to privacy. EFF calls the FBI's backdoor warrantless searches the finders keepers rule of surveillance, which, as a mother with small children, I just am like, come on, it's like so silly of a term, but nonetheless, like it's a real concern. If they get the information, they're going to hold on to it. And the Brennan Center said this time around that it thought the expansion of FISA was a gift to any president who might want to spy on their political enemies. And on the Democratic side of the aisle, you have Senator Wyden, who called the renewal bill this time around, when it was expanded, which we'll talk about, one of the most dramatic and terrifying, in his view, expansions of government surveillance authority. Nonetheless, the Biden administration was firmly in support of renewing the law, and it quickly signed the reauthorization when it got put in front of it. And so, you say, all right, so what about on the other side of the aisle? And again, we're in DC. Political flavor is going to be animating our discussion. The Republican side's also equally divided. I mean, that this time around, even though President Trump, in his first term in office, signed FISA back in to law. He signed a renewal in his first time around. Last year, he posted in all capitals, "Kill FISA" on his True Social platform. And whatever motivated him, I can't say, but nonetheless, that was his perspective at the time. On the other hand, the Republican chair of the House Intelligence Committee said that without FISA, we would be blind, and raised concerns that failing to reauthorize the bill would be a gift to foreign spying programs. And so, those are strong and hot words, really on both sides of the debate and on both sides of the aisle.
So I'm sure there's folks that just want it scrapped altogether, but there's also maybe some folks who are a little more measured who still have concerns and just want to tweak it, or maybe in greater ways than just tweaking, make some modifications. So what kind of changes were proposed?
I think the most significant proposed amendments had to do with whether the FBI would need a warrant before it could search the private communications of Americans that have been incidentally collected. So there was a bipartisan proposal. For example, there were several proposals in this regard, but I think one of the leading proposals came from Republican Senator Lee, together with Senator Durbin, where they proposed a bipartisan amendment that would have required intelligence agencies to either obtain a FISA Title I order or a warrant before accessing the contents of Americans' communications under 702, but not before running a query. So the government could still query to find out if there was data they might be interested in. Before they could access it, they would have needed a warrant. And they proposed several additional internal layers of supervision for U.S. person queries. I think that some people thought that was a comparatively measured proposal, but at the same time, that Warren amendment nor any other one passed. So none of the Warren amendments came through. You still can have warrantless searches under the law. And indeed, what actually ended up passing, in many people's view, sort of went the other way. It was an expansion of the law.
So yeah, what did pass? What were the expansions that you're talking about?
So we should go back up to my appellate geek focus on what are the definitions under the law. So if we look at electronic communication service provider, there's a very specific definition for what that means and what it doesn't mean. And there is a new section of that definition, which expands what an ECSP could be to now include, quote, any service provider with access to equipment that is being or may be used to transmit or store wire or electronic communications, as well as the employees, custodians, or agents of those service providers. David, I think it's hard to argue that isn't extremely broad. Like, that is a broad definition. And the statute only includes a handful of exceptions, like for a dwelling or a food service requirement. And there are privacy advocates out there who argue that this expanded scope could mean that almost any company, vendor, or any of their employees who touch the physical structure of the internet could be swept under FISA's scope and compelled to assist with FISA surveillance. I think it's a real question in our interconnected world who all this could apply to. I think it's worth considering how many companies and people that could impact, because it's not just telecommunication companies or even large data centers that have access to equipment that stores and transmits electronic communications. And for the people who are listening to this, when you join, I would suggest that you sit down and think to yourself, all right, am I an employee or a custodian or an agent of a service provider, an entity that provides some kind of a service that has access to equipment that may be used to transmit and store electronic communications? Because I'm going to guess that many of you are. And so it's an interesting shift in the modern world when we are so interconnected, and so many entities and people have their own equipment that can transmit and store that kind of information.
Yeah, so I guess maybe the last question for you on this is, we know where we are now, but what's going to happen next? Obviously, FISA debates never die; they just kind of, wait till the next time. So what's coming down the pike?
There are a couple of intelligence-related laws that are up for consideration in 2025. So it's possible that Congress could revise the definition of an ECSP in the course of considering those laws. But if that doesn't happen, given your point, which I completely agree with, I think we can expect the debate to pop right back up in 2026 when the law will be back up for renewal. And so, again, the national security concerns here are real and they're very important, but so are the concerns about U.S. citizens' ability to communicate privately in the modern world. And, as an actual national security lawyer with, serious chops from the government side and in private practice, I mean, I'm just interested with your focus on national security, David, like, how do you approach privacy issues?
That's interesting, right? Because as I said at the top of the presentation, like I don't think of myself as a privacy lawyer, and I'm not, but I do wind up encountering these issues a lot. Sometimes just in the national security work I do, but often when I work with some of our partners, right? We do have partners at Morgan Lewis, and they really are genuine privacy lawyers who spend a lot of time thinking and advising clients about this. And sometimes we wind up doing sort of blended work for clients because there is some overlap between the two. And one thing that I try to make clients understand is that there may be some efficiencies in thinking about your national security compliance, to the extent that some of these regulations apply to you. At the same time, you're thinking about data privacy because the solution for one may intersect with the solution for the other, so you kill two birds with one stone. But they're also very different problem sets, and so sometimes there's not that overlap, and you need to keep them in their respective lanes. Just I guess one example of that is in the privacy world, and this is the case whether we're looking at GDPR in Europe or California privacy laws or other states, or maybe eventually we'll have some federal legislation, who knows. The privacy issues are very much consumer focused, which makes sense, right? So when you look at what is necessary to protect privacy, you look at things like consent. If you're fully aware of what's being done with your data, and you consent to the data being treated that way, then we're largely okay from a consumer privacy standpoint. Or look at things like the right to be forgotten, which is a big piece of it too, right? If you go to your provider who has your data and say, I'm going to delete my account and I'm going to cease my service. So all the data you've collected while I was your customer, please delete it. As long as they're required to do it, from a privacy standpoint, we're okay. And from a national security standpoint, those are not necessarily going to be remotely satisfactory because a lot of the concerns about exploitation of data really don't go to consumer issues. They go to the effect on U.S. national security. And this is really reflective of an emerging realization in the government that I think now is generally acknowledged, but even a couple of years ago was not fully understood either outside the government or in the government, which is the way that even purely personal data can be exploited by a sophisticated adversary, especially a nation state adversary, for national security gain. People always understood, government data is sensitive, we get it. Or if you're a government contractor, your corporate data, may be sensitive from a national security standpoint, so we get that. But if we look at U.S. adversaries such as China and other countries, why would they care about my TikTok account, my Facebook account, my Gmail? And I get the confusion there. And the government itself, probably 10 years ago, didn't fully recognize that risk either. It was really primarily DOJ because of our counterintelligence mission and the fact that FBI was part of DOJ that first spotted those risks and kind of rang the alarm bell within government. And then we started to see more and more regulatory regimes that would account for the risk to sensitive data. So to pick a very simplistic example, and I can give you 100 examples, if you look at my social media, not mine personally, because I don't do social media,
No, me either.
but right, yeah, I mean, even after I left government, I still don't do it, right? And I'm much happier that way. So, but if I did it, right, you could look at it if you're a foreign intelligence officer and look at my entire professional network. And if I'm a government employee, or if I'm, retired from government like I am now, but I still have a professional network of government employees, you see that whole network. And, when you're seeking to, spot and assess and recruit assets, or you're trying to find, who to target for exploitation, whether it's cyber exploitation or what have you, things like people's networks are immensely valuable, right? I'll give you one other stupid example, but maybe it kind of illustrates the point. Let's say on my social media that I don't have, I post a cute cat video of my cat. I don't have a cat either, but let's say I did, and I talk about, my cat Fluffy. Well, how many people for their security question, for all their online accounts, use the name of their pet as their security question, right? So if now an adversary knows that the name of my cat is Fluffy, it may help them to harvest my credentials, right? Usernames and passwords. And if I'm really stupid enough to use those security questions on any government-related accounts, or if I use the same password for my government accounts that I use for my personal accounts, that are secured by these security questions, I've just given the adversary an easy way to try to get into my accounts. So again, these are kind of stupid and oversimplistic examples, but I think you get the flavor, right? Is that personal data, mainly of government folks, but it could be, the spouse of a government official. It could be their next door neighbor. It could be, the playmates of their kids, right? I mean, all those are potential, threat vectors. And again, we're talking sophisticated nation state adversaries that are very, very good at this, just like we are. So when we look at our sensitive personal data and the potential for exploitation, it's not going to give us, and by us I mean sort of the national security community, a whole lot of comfort to say, well, don't worry, that five-star general who has just let all of his data out into the wild, he consented, and so his consent cured the problem. From a consumer privacy standpoint, sure, that solves the problem. From a national security standpoint, he's compromised national security, and his consent to that really doesn't make it any better. So when I approach privacy issues, this has been a very long answer to your short question, Raechel. I approach it, from the standpoint of, now that I'm in the private sector advising clients, we need to be very pragmatic and efficient about solutions. So how can I help them comply with whatever government regulatory regimes deal with data privacy in a way that may be complementary of their efforts on the consumer data privacy front? So again, they can find some efficiencies and not reinvent the wheel all the time, but also recognize these are different problem sets and are sometimes going to call for different solutions.
When we were talking about this presentation and getting ready for it, one of the topics that we talked about were these recent Commerce Department regulations to regulate the supply chain for connected vehicles. And when I think about connected vehicles, I think about visiting in San Francisco and just seeing those cars get stuck in alleyways and just back up 7 in a row and they don't know how to get out. But yet, nonetheless, it is the world that is coming. And so, I understand you've been advising clients on those regulations, and also just, thinking about the new technology that's coming down that's going to impact everyday people in their life, these connected vehicles. How do we think about that from a data security perspective with its alignment with national security?
And, when you and I were talking the other day, I mentioned that because that really is sort of hot off the presses. Again, right now it's January 23rd, 2025. For you folks watching, this may be old news by the time you watch this, but as of January 23rd, 2025, it's been about a week since these regulations got issued by Commerce. I think they came out January 14th. And they're, by the way, now, like many things, subject to a regulatory freeze implemented by the new administration. So that may delay their implementation. But my prediction for those of you watching, in the future, is that they are going to get through. I think the new administration is going to be just fine with these regulations for reasons I'll explain in a minute. So I think notwithstanding this regulatory freeze, it may delay the effective date. They're supposed to become effective in March. Maybe it'll be a little bit later. But ultimately, I think they're going to, go through. And by the time all of you watch this, they're going to be enforced. Why do I think that the new administration is fine with these? Well, these new regulations that are going to regulate the supply chain for connected vehicles are predicated for their jurisdiction on an executive order. It's Executive Order 13873, and I remember the number because I wrote it. or I should say I was the initial drafter, right? I mean, nobody in government can claim to be, the sole author of anything, right? But I drafted that many years ago, and it was signed by then President Trump in his first administration. And now that same authority is being sort of repurposed. So that executive order was designed to safeguard the supply chain for what we call ICTS, which is Information and Communications Technology and Services. And why did I draft it? Well, I was in the office we mentioned at the start of this call, the Foreign Investment Review section at DOJ. And that office does things like CFIUS, which some of you may be familiar with, Team Telecom, which probably fewer of you are familiar with. But that office looks at foreign investment in the U.S. and national security risk it poses, and what the government needs to do to mitigate that risk. And so we were seeing a lot of transactions that didn't fall under our CFIUS authorities or our Team Telecom authorities or any other authorities. And so in that respect, there's kind of an authorities gap. So if there had been a risky transaction involving ICTS where a US telecom, let's say, bought equipment or procured services from a foreign vendor from an adversary nation, in many cases, there's nothing the government could do to stop that or to mitigate it. And so, at DOJ, we had seen those risks. And so, we decided to come up with this new authority. So we conceptualized it. I drafted the EO. We didn't actually house the authority in DOJ. We housed it in the Department of Commerce. So that's now run out of Commerce's Bureau of Industry and Security, BIS, which is the same entity that also does export controls and some other things. They actually stood up a new office within BIS called OICTS, the Office of ICTS, to administer this. So, that was signed by President Trump. Commerce promulgated the regs. We helped them, and those regs have been in effect for a while now. Commerce has not been hugely active. They're doing investigations. As we speak, there's active investigations they're doing. They've only taken one regulatory action so far. And this was a while back. They basically banned Kaspersky in the US. So, it has some teeth, but it hasn't been widely used. So what they did is they repurposed that executive order, relying on the same economic emergency that President Trump declared in that executive order to say, hey, just like ICTS is at risk of supply chain exploitation, connected vehicles are just cell phones on wheels, right? It's another form of ICTS. So when states regulate vehicles, out in California, for example, since a lot of our audience may be out on the West Coast, right? They're looking at traditional safety issues. They want to make sure that your electric connected vehicle doesn't crash into somebody else's connected vehicle, or run a stop sign and things like that. But which is fine at the state level. The feds are more concerned about national security exploitation. You can exploit data. There's an awful lot of data in these vehicles, including geolocation data, and geolocation gives you pattern of life. So again, let's put ourselves in the mindset of an adversary. If I'm that 5-star general, maybe I've got a car and driver, but if I'm driving myself, and my car is geolocating as it's going to, if an adversary can exploit that, that's going to tell the adversary where I go, right? When I go to work, what hours I go to work, where I'm going to be. And that kind of pattern of life data can be very valuable to target somebody for collection or other forms of exploitation. And that's just the tip of the iceberg, right? Because we're talking about privacy, I'm focusing on the data exploitation piece, but also think about other things like sabotage, right? If you can control a connected vehicle, you can crash that vehicle, right? Or you can say, all vehicles in the Pentagon parking lot are going to be disabled on X date, when we're going to launch an invasion of the US, right? I mean, all sorts of ways you can imagine a sophisticated adversary leveraging vehicles, whether again, they're consumer vehicles, which are being regulated now, or potentially, commercial vehicles down the road. So, a lot going on there, but privacy is a big piece of it. And again, it sort of goes back to this concept, Raechel, that you asked about earlier, which is how are national security privacy issues different from traditional consumer privacy issues? And this is therefore a good example, right? We're looking at the ability of an adversary not just to collect data to to sell you products or to, which is annoying and bad in its own way, but is, not going to endanger U.S. national security, but actually to use that data in a way that can put, U.S. national security at risk. So, this is, again, brand new stuff, and it's potentially going to be very broad. It's going to apply to vehicles and vehicle components coming from China, coming from Russia. So it's going to apply not just to Chinese and Russian auto manufacturers, right, the OEMs, but even to the US OEMs that are using components. It's going to restrict their ability, not for all components, right? Like the rubber that goes in your tires doesn't matter. But for certain components that are specified in the regulations, you'll be restricted in your ability to import vehicles or sell vehicles in the US with those components and subcomponents if they're coming from China and Russia. So I'm going to stop there. I could talk for an hour about connected vehicles, and I probably have in the past. But yeah, I'll stop there.
You just mentioned the risk with China. I think your office that you formerly were with, the Foreign Investment Review section, also has developed some regulations regarding sensitive data transfers to China. And those are pretty new too. They only came out last December, which is like last month also. So why was your office in charge of that? And could you tell us a little bit about those regulations and whether they're related from a privacy perspective to these new supply chain issues? Sort of where does that come in?
Yeah, and that was interesting because it is a little outside the traditional mission of my old office, right? I mean, which again does CFIUS and foreign investment issues. And sort of similar to the ICTS supply chain stuff. It really emerged from our growing sense, even back when I was in government, which it's happened 3 years, so it's been an emerging sense for a while that when we are fortunate enough as a government to have a transaction in front of us, if we see a risk to data, we can do something about it. We can prohibit the transaction, we can mitigate the transaction through all sorts of mitigation measures, but there's all sorts of other transactions involving data that don't involve a foreign acquirer or a foreign investor, and therefore may fall outside our regulatory toolkit. So again, similar to the ICTS, there's just an authorities gap where the very same risk to data may exist for a purely domestically owned company. So that's why my office had been charged with developing these regulations and implementing them. Unlike the ICTS regs, though, which, as I said, we housed in Commerce, DOJ is keeping these. So DOJ is actually going to be doing the implementation, the enforcement. In-house, in another part of their mission going forward. So, yeah, I think we've now talked enough about the risk that you've got a sense of why they care about it. So let me just talk briefly about what the scope of the regulations is going to be. So first of all, it's going to be focused not on every data transaction, right? It's they're trying to be surgical about it. And it's focusing only on adversary countries, which is defined in the regulations as China, Russia, Iran, North Korea, Cuba, Venezuela. So it's sort of the countries that you'd expect would be designated as adversaries. And it's going to look at 4 types of transactions. There's data brokerage, which I think we're all familiar with, and I think does give privacy advocates a lot of heartburn, right? Even, the very same, ironically, privacy advocates who may have concerns about things like FISA, when the government does it, are also worried when it's private companies doing the same thing, right? Selling data to data brokers.
Yeah, that's what you meant by data brokerage. I was going to say, we all may well be familiar with it, but let's make sure we know what we're talking about. Yeah, so
yes, and I need to be careful not to assume too much, right? Because some of us live and breathe this stuff, and some of us spend our days thinking about more interesting things. But yeah, when we talk about data brokers, we talk about folks who buy data, right? They're data aggregators. And so, when you're on one internet platform, you provide your data for that purpose, but typically they have the ability to take your data, sell it to other folks, whether it's for advertising or other things. And that is a huge, huge business. So from a privacy standpoint, that gives a lot of folks concern. And again, for the same reason, it gives national security folks some concern because it can be used not just for commercial purposes, but also for national security purposes in the ways I talked about before. So that's part of the scope of the regulations. And then the 3 other things that are going to be covered are investment agreements, employment agreements, and vendor agreements. So for vendor agreements, think of things like you're a US company, but you've got a vendor in China doing your IT. And in the course of doing that, data gets transferred to that vendor. That's the sort of thing that the regulations are trying to get at. And again, they're trying to be surgical. So there's 6 categories of data that are defined as sensitive. It's very technical, so I'm not going to try to get into all of it. But it's things like personal financial data, genetic or genomic data, health data, things like that. Things that from both a privacy standpoint and a national security standpoint, I think we all can understand the sensitivities regarding those. And again, I don't want to assume too much. So maybe I'll just pause and give an example of how this can be exploited. Why do we care about things like financial data? Well, from a privacy standpoint, I think it's clear why we care. From a national security standpoint, if an adversary government can get financial data that may reveal that I'm in financial distress, and if I'm a government employee or if I'm the spouse of a government employee, that may tell the adversary that I'll be susceptible to a bribe, right? If they come and throw $100,000 at me, right? Or let's say it's my medical data, and let's say I'm seeing a psychiatrist, and I've got a job where seeing a psychiatrist could be problematic, right, for that employment. That opens me up to blackmail if an adversary has that health data. So again, for privacy, we all know about HIPAA and things like that and why we treat it as sensitive from a privacy standpoint. But when you think about, the types of coercion that a foreign intelligence service, routinely seeks to leverage, whether it's, blackmail, bribes, what have you, you can see how the very same type of data could be sensitive for that purpose too. So when data is being transferred to these adversary countries in one of those types of transactions, data brokerage and the rest, that's where you're going to trigger the regulations. The regulations are more stringent when it comes to data brokerage. So there, when the regulations apply, unless an exception is applicable, and there are some exceptions in the regs, it's just a straight up prohibition. You just can't do the transfer. With respect to the other types of transactions, so the vendor agreements, employment agreements, and investor agreements, the transaction may be allowable if you comply with certain cybersecurity measures that the government is concurrently releasing. So it's a little more permissive in that respect. So that in a nutshell, is the regulations. And again, it seems strange for DOJ, right, which is a law enforcement and a national security agency, to be in charge of data security until you stop and realize that these are not just privacy issues, and for the reasons we discussed, they're national security issues. So for a counterintelligence agency, then it starts to make a lot more sense that they be in charge of regulations like these.
David, I think a big takeaway from your comments, and one that people may not have previously appreciated, I'm not sure I fully previously appreciated, is that supply chain security really involves data security in a major way. I mean, the data security and privacy issues are in the supply chain security issues also. So other than in the ICTS context, which we think we've talked about a lot, is data security an issue in sort of other types of supply chains in a way that would be impactful here?
Yeah, it is. And, I'll just give one example. And it's an example that, we've not talked about yet. We've been talking a lot about things like telecom and ICTS and connected vehicles. So let's talk about something totally different, which is biotechnology and biomanufacturing. That is also an issue of increasing sensitivity. In the past, I've sort of categorized it in my head as kind of a tier 2 national security issue. And these are made up tiers, right? But when I'm advising clients about things like this, if I got a client that is involved in semiconductors, artificial intelligence, quantum computing, I tend to think of those as like the tier 1 issues, where if you've got, for example, a Chinese company involved in those technologies or a US company that's procuring, services from a Chinese company involving AI or quantum, that's where there's going to be some potential regulatory risk because the government views those as high risk areas. Biotech and biomanufacturing, I've always kind of thought about as one level below that. But I got to say that's been changing. So, in my mind, that's maybe still tier 2, but rapidly approaching tier 1. In the past 1 or 2 years, especially here in Washington, at least, but I think elsewhere as well, there's been increasing discussion about biotech, and particularly in the context of US-China competition. So just one example I'll give you, because it again involves supply chains, which is what you asked about, is a piece of legislation called the Biosecure Act. And that was considered in the last Congress, so the 118th Congress. And it was passed by the House of Representatives, never actually made it to the Senate. So that bill didn't become law. So it may be reintroduced in this Congress, it may not. So right now, to be clear, it doesn't exist, nothing to worry about. But it's just interesting, as instructive as another flavor of supply chain risk. So what the Biosecure Act would have done is it would have given the Department of Defense, in coordination with other agencies, new authorities to designate, quote, biotechnology companies of concern. And those are biotechs from the kind of countries that, again, you would imagine, right? The Chinas and Russias of the world, where the U.S. has some national security concerns that are a little bit heightened. And if those companies were designated as biotechnology companies of concern, then that would have precluded the ability of the U.S. government to contract with them, but also, sort of collaterally precluded the ability of other companies to contract with them if those companies are government contractors. And that's how the U.S. government often tries to, sort of use its market power, and it is a major contractor, right, to influence policy, where and very often they do this just sort of the camel's nose under the tent, which may be followed by other measures down the road. But they start off with government contracting, where they'll name a couple of companies that get put on some kind of blacklist, and then they say, okay, you can't contract with us, and if anybody else uses you, they can't contract with us either, or at least they can't use your products to contract with us. So it's sort of using the purchasing power of the federal government. But it does reflect some genuine policy concerns by the government, which involve supply chain and other things. So part of their concern in the biotech space is that when you get foreign companies in the supply chain for biotechnology, those foreign companies may come into possession of things like genomic data. And for reasons I think we can understand, genomic data is regarded as sensitive, both from a traditional privacy standpoint, but also from a national security standpoint. So again, go to your stupid, oversimplified example of a government employee, maybe a high-ranking one, whose genetic data is procured by a foreign adversary, right? And this is why I personally, just like I don't have social media, I've never done these fun genetic tests, and maybe I'm paranoid, and so I'm missing out on all sorts of fun insights about, my ancestry and, where I come from. But I don't want my genetic data floating around either in the US or overseas. So, and again, you can imagine how an adversary could exploit that data. If they know that I've got some rare disease and I'm going to keel over, by the age of 50, I'm not sure I want to know that. Maybe I do want to know it, but I certainly don't want my adversary having that information, right? So, supply chain is very broad, right? And it goes into all sorts of sectors, maybe, beyond the ones we traditionally think of. And it's not just a privacy issue, but privacy is certainly a big piece of it.
David, this has been extremely fascinating. I very much enjoyed chatting with you about it, and I think we are drawing near the end of our time. So I think I would like to say we really appreciate again Berkeley giving us the opportunity to have this fascinating and multi-pronged discussion together through their program. So thank you, Wayne.
Thank you. This is, like I said, a topic we don't hear a lot about, but obviously impacts a lot of people out here that need to hear more about this before they accidentally get themselves in a serious bind.
It's true.
So yeah, there are real ramifications here for innocent mistakes. So with that, I want to thank you. I know these kinds of programs take a lot of time, and you're donating that to Berkeley and to the listeners. I thank you very much for really helping us out.